Next item is item 5A, which is a public hearing to consider a text amendment to the Crescent Creek Design Manual, and I'll ask the clerk to perform the first reading at this time.
A resolution granting an amendment to the Crescent Creek Design Manual for lots 102 and 103 in the Crescent Creek subdivision and amending rezoning ordinance 4922-03 and 5796-04, all in accordance with the provisions of comprehensive zoning regulations for the city of Raytown, Missouri.
Okay, would anyone on the board like to share any ex parte communication they may have had on this subject? None appearing. Ask the Mr. Benson if you'd like to introduce the application, please.
Yes, very briefly. Crescent Creek is a traditional neighborhood design or T&D type subdivision. As such, the developer, when it was proposed, it required rezoning, and the rezoning included a planned district overlay. The planned district overlay included a design manual to guide the development of the lots and the physical appearance of the homes in the subdivision and the layout of the lots as they were developed. One of the standards contained in the Crescent Creek Design Manual specifies that all front-loaded lots, which are lots that do not have alley access, that a single-lane driveway is to be the maximum driveway width allowed between the front plane of the house and the street. An amendment to this requirement is being sought by Buzz Delaney, who is owner of Delaney Construction. Delaney Construction purchased two homes located at 9405 and 9504 and 9508 East 57th Street that had previously been under construction, had started under construction by another builder who had, after starting construction, went bankrupt. Delaney Construction has since bought the two homes or two lots, continued construction on those lots, and if you've driven by those homes are enclosed now and nearing completion. However, as they neared completion, one of the requirements, they both have two-car garages on them, which would require the driveway width to narrow down as it gets to the front of the house to a one-lane width or to one-lane wide driveway. The garage, however, is only set back about 10 feet on each of these houses from the front plane of the house. So in that 10 feet, the driveway width has to narrow down, which creates a problem of cars being able to back a car out of one of the garage spaces and make that turn to keep it on the driveway. Therefore, he's asked for an amendment to this design standard, which in effect in this case is a variance to the regulations, because this amendment only applies to these two lots in question. Mr. Delaney is here tonight. Talking to him prior to the start of the meeting, he said he didn't necessarily have anything more information to add to this, but he'd be happy to answer any questions that you may have, as would I. So I'll stop there.
Questions of Mr. Benson at this time? Ms. Melson?
I do have a couple of questions. On, it would be page 2, under section 2, number 3, it says single opening garage doors with a pillar in between shall be used for a double car garage. Can you explain that? I mean, that's two garages, correct? And there has to be a pillar in between.
It's a two-car garage, but instead of having one garage door that's wide enough for two cars, it's two separate garage doors, one car wide each, with a pillar on the facade of the garage door. It's on the building itself that separates the two garage doors.
Okay, and so it has to be that way?
Yes.
So there can't be one large garage door.
Correct. And that
goes up and you get two cars in.
Right. These two homes comply with that standard. It's two separate garage doors side by side.
And then can you explain number 5 for me?
It's a general statement. Other architectural elements could be arbor. I've seen garage doors where they put a little arbor across the front of the garage door, and it just makes the garage door appear to be recessed a little bit more than it really is. It could be other just architectural details on trim work or other things like that.
Is that a requirement?
Yes. All items 1 through 5 are required. The only variance that this application only applies to item number 4 on that page out of those 5. It's item number 4 this amendment applies to. The other 5 they comply with, or the other 4, excuse me, of the 5.
Mr. Mock.
Okay. Now, per our conversation tonight, you had mentioned something about if the garage was set back, okay, could he have went ahead and brought a double wide driveway out during this? Or would he have to bring a double wide back to a single drive?
A double wide would be allowed to the side of the house back to the front of the garage. But at the point where it gets to the front plane of the house, which does not include the porch, at that point it has to narrow down to 1 car width driveway.
Okay. Okay, with the driveways across the street, I know they are detached, but they're a double wide with 16-foot garage doors. How did that all work out?
They were not considered front loaded. They were because they're corner. Well, let me back up. Let me rephrase. They're front loaded, but because they're corner lots, the design manual allows them to be double wide all the way out because they're set closer because of being a corner lot. They're placed closer to the street, so the design manual actually allows them to be that width, the driveway to be that width.
Okay, so with any other builders coming in with where they'll have to come in to get their permit, can they, be notified about this variance, told about it before they?
Yes.
Yeah.
Yes, they can be.
That would be great.
And well, we've obviously had this conversation about this because the problem here was the distance the garage is from the front plane of the house.
Yes.
So our building officials now aware of this issue. We're aware of this issue. Obviously, just what the builder at the time when the plans were submitted wasn't obviously aware of it or didn't connect the dots, nor did we catch it at that time. So.
Okay.
Other questions of Mr. Benson at this time? Okay. The applicant is here. Do you wish to say anything, sir? Okay. At this time, I'm going to move to public comment. Would anyone in the audience like to speak to the board regarding this particular matter?
Even though I don't live in that area, I find it hard to understand why they only have such narrow driveways and require the pillared garage door, because I tell you, I cannot get a car in and out of one of those, and I would have a difficult time getting down that driveway myself. I think definitely that driveway should be widened. Thank you.
Thanks, Andy. Anyone else in the audience that'd like to speak to this matter? Okay, we're going to move past public comment. Staff have anything else to add at this time?
Have nothing further.
Would the board like to continue discussion? This is, again, the first reading. We will hear this again if you so move to make it a date certain of February 1st.
So moved.
Mr. Hamilton's got the motion to move to date certain February 1st, seconded by Ms. White. Discussion before we vote.
I do have a question. There is a letter November 15th from Mr. Delaney, and it's referencing Tom Cole and an email. Was there a reason that Mr. Cole was contacted and not Community Development?
I'd have to defer to Mr. Delaney to answer that. Mr. Delaney had contacted Beth, myself, Mr. Cole, different people in City Hall. I think it was just he happened to had exchanged emails with Tom and happened to address this letter to Mr. Cole.
Okay, thank you.
Other questions of staff or discussion before we vote? Call the vote, please.
Alderman Hamilton?
Yes.
Alderman White?
Yes.
Alderman Melson?
Yes.
Alderman Kramer?
Yes.
Alderman Ertz?
Yes.
Alderman Perdue?
Yes.
Alderman Van Buskert?
Yes.
Alderman Asher?
Yes.
Alderman Lightfoot?
Yes.
Alderman Mock?
Yes.
Buzz, thanks for your patience. We'll see you on February 1st. Item number 6, ask the clerk to perform the first reading on this.
An ordinance amending Chapter 13, Offenses and Miscellaneous Provisions, Article 6, Offenses Against Public Order, Sections 13-67 through 13-70 regarding weapons and concealed weapons.
Mr. Willett, anything to add on this subject, sir?
Yes, I think a bit of explanation perhaps would be useful.
I sent my partner to get this through here in the December meeting, and I thought the board did admirably, and you had approved this. But since that time, the police department, specifically Captain Frank Strandmeyer and City Prosecutor Ross Nigro, had a chance to review the finished product and requested that we look at it and make some changes. And these, I believe, that we met the major intent with the first bill before you, which was to bring our current code in compliance with Chapter 571 with respect to the important provisions of the statute and the ordinance regarding the unlawful possession, manufacture, and transporting of weapons, the unlawful use of weapons, discharge of weapons in the city. I know there were some discussions of whether that language was so broad, however, that perhaps we were even trying to exclude the use of BB guns within the city. So Captain Strandmeyer brought up some changes to make it exactly mimic Chapter 571, and those are the first three modifications before you, which permit possession of firearm silencers by licensed collectors and have a definition in reference to antique firearms for consistency with 571. That's modification 1. Modification 2 was modifying your section 1369B1 to make some grammatical changes with respect to the exception in the law for retired peace officers who have proper credentials that they can carry a concealed weapon, and that we carried through in this amended bill. And that's what modification 2 and 3 deal with. And then I think of most interest to you and most important was, after looking at this, your city prosecutor, Ross Nigro, who had drafted the original bill that had a listing in section 1370.A2 of numerous items that you might have called potential weapons in the first one, has decided, and I agree, that to simplify this, we just reduced that to merely define that the discharge would not be permitted of firearm only, and firearm is defined, and numerous of the other weapons, lasers, sharp-barreled things, and other things were deleted out of 1370A2. As a result of deleting those things, we no longer need the exception for paintball guns, which had been in Section 4, since clearly they're not under the definition of firearm, and so we deleted that Section 4 out of it. So the revised bill has been circulated and revised staff report, and I apologize to you that that revising kept up even through today. It is my understanding now has been reviewed and approved both by the police department and City Prosecutor Ross Nigro, who had done some of the initial work to bring it forward to me in the first place. So I'm still comfortable with all the work I did with respect to 571 originally, and now these 4 modifications are asked for, are considered for your approval, and hopefully we can then put this matter to rest.
Questions of our legal counsel? Ms. Melson.
I do have a question. It's over here. And my question was on the original board request. So now I don't know if it's still within it. But it basically was on allowing retired peace officers the right to be exempt from law.
That's the right to have them exempt from the concealed carry law. They are allowed to carry concealed carry under the state statute, and so we're making ours modified so they're also allowed to carry concealed carry under our ordinance.
So do they have to go through the same requirements as a normal person does to get a concealed carry, or they don't?
I don't believe so. Do they, Chief? I believe that comes as a result of their being a status as a peace officer issue.
They have to qualify here to carry. The carry conceal is different than to qualify. There are two different issues, carry conceal versus, and I want to make sure I understand your question. You're talking about carry conceal versus qualifying.
Well, I guess my question really is that why should retired peace officers be exempted from the law regarding this?
Because,
and that was on the, and then my question from
because the state statute made them that way is the answer.
Oh, okay. So it's already within state statutes that retired police officers are exempt from the concealed.
Yeah, and the state statute changed. I believe, I'm talking to Ross Nigro September 8th. I don't know if that date's exact or not. So some of this has changed because of the recent state statute change.
Okay. Because I know that it, on page 6, it does have on this new one, I guess maybe it's in the other one too, about what the qualified retired peace officer means, and then some, and then it's got the photo identification issued by the agency for which the individual retired. That's all.
That's all required by the new amendment of Section 571.030 with respect to the state officers, yes.
Okay, thank you.
Other questions? No questions of Mr. Willis?
Sorry.
Mr. Ertz?
Is this something that we should suspend the rules so the officers know what the rules are on the streets? Would that be helpful?
I think it would be helpful in terms of you all dealt with the issue and have resolved it, and I think if we suspended the rules and got this approved tonight, then I don't think you'd have to have another meeting. We wouldn't have to go through this again. In that sense, it would be helpful to the orderly administration of justice, yes.
I'll make a motion to suspend the rules.
Second.
Okay. Good.
Wow, that was well put.
That was awesome.
Have my moment.
We have a motion made by Mr. Ertz to suspend the rules, and I didn't get the second. I apologize. Mr. Azier had the second on that. We're on discussion for suspension of the rules. Ms. White.
And I hate to disagree with staff, but in this case, I'm going to. And the thing I want to say to my fellow board members is that suspending the rules is serious and should not be taken lightly. If I thought that this was a safety concern for the city, by all means, I would say suspend the rules and let's move on. However, it's not. If you look at the changes that are being made, they're administrative type changes. They're not life-threatening. They're not huge safety concerns for our community. And so I think that in this case, we should not suspend the rules and just let it go through its second reading on February 1st.
Further discussion on suspension of the rules. Call a vote, please.
Alderman Ertz?
Yes.
Alderman Azier?
Yes.
Alderman Hamilton?
Yes.
Alderman Van Buskirk?
Yes.
Alderman White?
No.
Alderman Pardue?
Yes.
Alderman Melson?
No.
Alderman Mock?
Yes.
Alderman Kramer?
Yes.
Alderman Lightfoot?
Yes.
Perform the second reading, please.
An ordinance amending Chapter 13, Offenses and Miscellaneous Provisions, Article 6, Offenses Against Public Order, Sections 13-67 through 13-70 regarding weapons and concealed weapons.
Chief, anything to add before we go to discussion?
Yes, I'd like to thank Mr. Willerth and Ross Nigro and their patience in getting this to Mayor State statute and appreciate all the work they did on it. Thank you.
Thanks, Chief.
So moved. Second.
Mr. Azier has the motion for approval, seconded by Mr. Lightfoot. Discussion before we vote. Ms. White,
No, sir.
call the vote, please.
Alderman Azier?
Yes.
Alderman Lightfoot?
Yes.
Alderman Mock?
Yes.
Alderman Pardue?
Yes.
Alderman Melson?
Yes.
Alderman Hamilton?
Yes.
Alderman Van Buskirk?
Yes.
Alderman Kramer?
Yes.
Alderman White?
Yes.
Alderman Ertz?
Yes.
There being no apparent or no business before us remaining at this time, I'll ask for a motion to adjourn. Mr. Kramer has a motion to adjourn. Is there a second? Second by Mr. Mock, was it? All in favor of adjournment signify by saying aye. All opposed, same sign.